Hey Megan, would you please make your screen uh, full screen for the timer so I can show Randall? Good morning. This is the 9 a.m. captions check. Microphone check. 1, 2, 3. Mic check. 1, 2, 3. Good check.
Microphone check. Microphone check. Testing 1 2. Testing 1 2.
noisy all of a sudden. Yeah. All right. Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. It's 9:30 a.m. on Wednesday, January 10th, 2024. Happy New Year, everyone. We got additional volume. That's great. Happy New Year, everyone, and welcome to TCEQ's agenda meeting. With us today are Commissioners Emily Lindley and Bobby Janeka. I'm John Neerman. We're also joined by our General Counsel, Mary Smith. For those who are joining us virtually, I'll ask you to please remember to keep your microphones muted when you're not speaking. For those who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to do so. We will inform speakers of their time limits. Registration has now closed, but if you've not registered and you'd like to address the Commission on a particular item, we'll do our best to accommodate that request, and we'd ask that you email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and again, we'll do our best to accommodate that request. Thank you all for being present. Ms. Smith, please call item 1.
Item 1 is the application by WestGen LLC for the renewal of air quality permit number 21589. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I think it's appropriate that our hearing requester, Ms. Davis's concerns have the attention of our Office of Compliance and Enforcement, but I looked again at the compliance history classification this morning and still agree with the Executive Director and the Office of Public Interest Counsel that under Section 382.056 of the Health and Safety Code, there's no right to a hearing on this no increase renewal. Commissioner Lindley.
I feel the same way.
Well said. I agree.
I can make a motion then if we're ready. I would move that we find that there's no right to a hearing on this application pursuant to Texas Health and Safety Code, Section 382.056, that we deny the hearing request of Susie Davis, that we issue the renewal of air quality permit number 21589 to WestGen LLC as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by RNL Concrete LLC for issuance of air quality standard permit for concrete batch plant registration number 171631. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, we have a single request on this item. Ms. Borking resides within 440 yards of the proposed plant, and her timely hearing request expresses personal concerns that are relevant and material to this registration. So I would grant her request and refer the matter to SOA on the following issues. First, whether the applicant met the notice requirements, and then whether the proposed plant will negatively affect air quality, have an adverse effect on the requester's health, have an adverse effect on livestock, or impair the use and enjoyment of the requester's property. Commissioner Lindley.
I'm in agreement on the issues and the granting of the party.
I'm likewise fully in agreement.
And I think ADR would be appropriate
I
here.
agree.
Okay, and allow 180 days for the hearing.
I agree.
I have a motion that captures that. I move that we...
What? One moment.
One thing I will note too, there was a request for reconsideration. Were you about to speak to that? I was going to recommend that we deny that.
Good.
Sorry, Commissioner Janeka, interrupt.
I also have a motion to capture that. I'll read that now. Thank you. I move that we grant the hearing request filed by Carol Borquin. We deny the request for reconsideration, refer the application to SOA for a contested case hearing concerning the following issues. A, whether the proposed facility will negatively affect air quality. B, whether the proposed facility will have an adverse effect on livestock and the requester's health. C, whether the proposed facility will adversely affect the use and enjoyment of the requester's property. And D, whether the applicant substantially complied with applicable notice requirements. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts and set a hearing duration of 180 days from the date of the preliminary hearing until the issuance of the proposal for decision.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
The third item today is the consideration of the petition filed by Catalonian LLC for the Commission to involuntarily transfer TCEQ permit number WQ0015843001 from Aguilas Robles LLC to petitioner, or in the alternative, to revoke the permit or revoke and reissue the permit to petitioner. The parties have been notified that the Commission will take oral argument on this matter. The petitioner, as movant, may speak first and save part of its time for rebuttal. We'll have the permittee next, then ED, and then OPIC. Each party will have 5 minutes to present their argument. And I believe we have Mr. Sarahan for the petitioner.
Good morning, Mr. Sarahan.
Good morning.
I'm not sure we've got your mic on. Do you have a green light in front of you?
I do, sir.
Okay. Okay, I think we got it turned on.
Great.
Go ahead when you're ready, sir.
Thank you. Chairman, Commissioners, General Counsel, I'm Paul Sarahan, counsel for Catalonian LLC. With me today is Catalonian's representative, Greg Loyne. This matter highlights an essential feature of TCQ's permitting process: the executive director's necessary reliance on the applicant to provide true, accurate, and complete information in its permit application. In the pending matter, the issue is land ownership. Petitioner understands that because of understandable resource limitations, the executive director's staff does not independently verify an applicant's assertion of land ownership, but instead relies on the applicant's statement of ownership and its certification that that information is true, accurate, and complete. Here, the initial applicant, Callie Kate, falsely claimed ownership, and the permit was issued in part based on that false claim. Callie Kate then sold that permit to Aguilas Robles, who sought and obtained a transfer of the permit from TCEQ. To do so, Aguilas also falsely claimed to be the owner of the land that is the site of the permit. The executive director agrees with petitioner and OPIC that Aguilas falsely represented its land ownership, stating, quote, "When Aguilas submitted the transfer application, it represented to the ED that it owned the property." Making a false or misleading statement in a permit application constitutes a significant violation and is not one that may be corrected after the agency has issued or here transferred the permit to the applicant. Aguilas cannot simply obtain a permit it would not otherwise be eligible to receive and, quote, correct that violation by simply applying to amend the permit to which it was never entitled. Because TCEQ relies so heavily on the truth, accuracy, and completeness of an application, significant consequences must be levied against an applicant who fails to meet that standard, particularly on an issue as fundamental as land ownership. Under Texas Water Codes Section 7.302B5, the Commission has the authority to revoke, suspend, or revoke and reissue a permit where an applicant misrepresents or fails to disclose fully all relevant facts in obtaining the permit. That is what happened here. Petitioner respectfully requests that the Commission grant the petition and exercise its authority to revoke and reissue the permit either directly or following referral of the matter for a hearing before SOA, or alternatively, involuntarily transfer the permit to petitioner under 30 Texas Administrative Code 305.64I. Again, directly or following referral of the matter to SOA. I reserve the remainder of my time, and I'm available for any questions you may have.
Thank you, Mr. Sarahan. I have none right now. Commissioner Lindley?
No, thank you.
Commissioner Janeka? All right, thank you,
Thank
sir.
you.
And we'll hear next from the permittee, Ms. Gilbert. Good morning, Ms. Gilbert.
Morning, Chairman, Commissioners, General Counsel. I'm Helen Gilbert on behalf of Aguilas Robles, LLC. Aguilas appreciates that Senator Campbell and Representative Isaac have taken the trouble to weigh in on the petition. They are 100% correct in their assessment that what the petition is requesting would lead to bad precedent and trigger legislative action possibly in the future. In addition to that, however, what the petition is requesting is already unprecedented. The petition has presented you a complicated fact scenario. That is by design. It hopes that you will find that the procedural background here is so complicated that you will just refer the case to SOA for a hearing on the involuntary transfer and revocation. Procedural history here is really not that complicated, and a referral to SOA would entirely be unnecessary and, again, unprecedented based on the facts in the law. I want to address briefly revocation and involuntary transfer, as neither of those remedies is appropriate in this case. Revocation. First, your rules have been on the books for a very, very long time, and the incidents of revocation are very few and far between. It rarely happens, even in the most egregious situations, because the legal bar in 305-66G1 is very high. It's a two-part test. One, that the violation or violations must be significant and, not or, but and, there must be no attempts to make a substantial effort to correct the violations. Petitioner is a subsequent land purchaser, actually two landowners removed from the original landowner when the original permit application was filed. And what petitioner is doing is complaining about alleged errors in the underlying permit application. Aguilas is not responsible for any errors, even assuming they occurred, and we obviously debate that, that occurred with the original application. However, they don't stop there. They also accuse Aguilas, again this morning, of violating rules in the permit transfer process. I will point you to Exhibit A of our filing in response to the ED and the OPIC, where it's very clear that the applicant engaged their engineer to do both the transfer and the major amendment at the same time, almost contemporaneously, after the adjacent property was purchased. It was never Aguilas's intent to seek a permit for land that it did not own. And I would point in the transfer application form, the very important language that we're glossing over, where you identify property where the facility will be located. Now, as to involuntary transfer, those are also very rarely used rules in this context. There are 8 factors there, even if one applies. Again, there's that word and. The entity to whom the permit would be transferred has to have demonstrated capability and willingness. That's the past tense. So there's been no showing by Catalonian that it is capable or willing to be the permittee and to step in the shoes of Aguilas in this case. That's another essential part of the rule that the petitioner. And by the way, that involuntary transfer process can't just become a de facto permit hearing on behalf of the petitioner. What the petition is requesting today is really fairly astonishing. It completely does away with the due process rights of Aguilas, and that's important. There was a contested case hearing on the underlying permit that happened over 2 years ago with parties that aren't even at the table today. That is a final order of the commission, and the petition is really a collateral attack of that order. That is impermissible.
I'll ask you just to finish your thoughts, Ms. Gilbert.
Okay, as to falsification, sadly, here we are again, and I would just point out that under 2005-052 of the Government Code, you're prohibited from revoking a permit without a showing of knowing falsification, and I'm happy to answer any questions.
Thank you, Ms. Gilbert. I have none. Colleagues, any questions? All right, thank you. We'll hear next from the Executive Director's Office. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Aubrey Puelka with the Environmental Law Division. Joining me today is Deba Dutta with the Water Quality Division. The ED opposes this petition and recommends the Commission deny Catalonian's request. Under the original 2019 December permit application, the original permittee, Cali Kate, represented to the ED that it owned the property on which the facility was to be located. At the April 28, 2021 agenda meeting for this application, the Commission determined there was one affected person and referred one issue regarding odor to SOA. Following the preliminary hearing, the case was remanded back to the Executive Director, and the ED issued the permit to Cali Kate in September of 2021. In January of 23, Aguilas filed an application to transfer the permit from Cali Kate to Aguilas. The ED approved the transfer in February of 23. Cali Kate represented to the ED in its original 2019 application that it owned the property on which the facility was to be located, and this issue was not contested. The ED standard of practice is to rely on representations made in the application as complete and accurate. Based on the representations made by Cali Kate, the ED issued the permit. In March of 2023, Aguilas submitted an application for a major amendment to the permit. The requested amendment includes a change in both the location of the outfall and the proposed facility. Aguilas provided additional information to ED staff, including a warranty deed, a title and lien search, a map, and a perimeter description showing their property interest in the site of the proposed facility. The ED does not find that Catalonian has demonstrated that an involuntary transfer is appropriate because, as discussed in the preamble, when the involuntary transfer rule was adopted, these types of transfers are intended to apply to entities that fail to comply with the terms of a permit to minimize or eliminate damage resulting from the noncompliance. There is no evidence to suggest that Aguilas will not comply with the terms of the permit because the facility has not yet been constructed. Aguilas does not own or operate another facility, and they have a compliance history of unclassified. One of the reasons listed in 30 TAC 305.64I as a basis for the Commission to involuntarily transfer a permit is if the facilities have not yet been built and the permittee no longer has sufficient property rights in the site of the proposed facilities. However, as previously stated, Aguilas' amendment application seeks a change in both the location outfall and the proposed facility location. The major amendment application, if granted, addresses this issue. There are 9 discretionary reasons listed in 30 TAC 305.64I for which the Commission may transfer a permit involuntarily. However, Catalonian's petition does not demonstrate that Commission action pursuant to any of these scenarios is appropriate in this case. Further, the Commission may revoke a permit for good cause. However, the Commission must find that the violation is significant and that the permit holder has not made a substantial attempt to correct the violation. Catalonian does not demonstrate that Aguilas has committed a significant violation, has not made a substantial attempt to correct the violation. If Aguilas committed a violation with regard to the location of the facility, its amendment application is a substantial attempt to correct its violation. While the ED is always concerned when there is a question of property ownership in regards to the location of a proposed facility, the facts in this case do not warrant further commission action on Catalonian's petition. The ED respectfully requests that the commission deny Catalonian's petition. Thank you, and we are available for questions.
Thank you, Ms. Palicka. I have none. Colleagues, any questions?
Thank you.
Seeing none. Good morning, Mr. Martinez. How does the Office of Public Interest view this matter?
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm with the Office of Public Interest Counsel, for the record. We've reviewed the briefings by the petitioner, Aguilas Robles, and the Executive Director in this matter and conclude that good cause does exist for revocation of water quality permit WQ00158430001. Alternatively, we believe that the Commission may order a hearing to further develop the record and give the permittee an additional opportunity to present any evidence that may not be clear from the briefings. Section 305.66 of our rules and Texas Water Code Section 7.302B establish that good cause for revocation includes the permittee's failure in the application or application process to disclose fully all relevant facts or the permittee's misrepresentation of relevant facts at any time. The record demonstrates that Aguilas Robles misrepresented ownership of the site where the permit authorized construction of the proposed wastewater treatment plant in Section 7 of the transfer application. They do not currently, nor have they ever owned this property. The petitioner does. We are of the opinion that this act clearly falls under the misrepresentation of relevant facts standard, establishing a good cause for revocation. However, before revoking the permit, the Commission must additionally find that this violation is significant and that the permit holder or applicant has not made a substantial attempt to correct those violations. OPIC believes this violation is indeed significant. The permittee was not eligible for the permit they currently hold because they did not have any ownership interest in the site of the proposed facility designated in the application. This constitutes a fatal flaw. Such a flaw is of sufficient magnitude that it cannot be cured post facto or shielded from revocation by pursuing an amendment. The permittee cannot at this late hour correct compromising the integrity of our permitting processes and negatively impacting public participation. The transfer issuance process does not provide notice to landowners because it's predicated on the notion that the original application was true, correct, and fully disclosed but did not misrepresent relevant facts. This was simply not the case in this instance, and the public was wrongly excluded from correcting that misrepresentation. For this reason, for these types of defects, we cannot support an amendment application that, as on its face, meeting the substantial attempt to correct standard. And lastly, as we stated in our brief, we do not believe there is any need for an interim permittee because there are no continued operations to effectuate on an unbuilt facility. The same can be said of revocation or involuntary transfer, rather, generally. However, if the Commission desires to gather evidence as to whether the petitioner is capable of assuming responsibility for compliance with the permit, OPIC would support a hearing on that issue as well. And thank you. I'm available for any questions.
Thank you, Mr. Martinez. I have none. Colleagues, any questions? Seeing none. Mr. Sarahan, you have just shy of 2 minutes left for a rebuttal.
Thank you. Just a couple of points. Ms. Gilbert indicated that this is a complicated fact pattern. It simply isn't. Callie Kate falsely claimed land ownership, and so did Aguilas. Those are the facts, and the Commission can decide what it wants to do in response to that circumstance. In addition, the point about collateral attack is off base because all revocation proceedings happen after the Commission has issued an order, and so it's simply not relevant. In closing, I would just say that this is a matter of truth or consequences. Aguilas failed to tell the truth, and petitioner requests that the Commission require Aguilas to now face the consequences for that failure. Petitioner respectfully requests the Commission grant the petition, revoke and reissue the permit, or alternatively transfer the permit to Catalonian. We appreciate your consideration, and we're available again for any questions you may have.
Thank you, Mr. Sarahan. I have none. Any questions or comments, colleagues? All right. Well, colleagues, here's my analysis. The petitioner has asked us to involuntarily transfer the permit to it, or in the alternative, to revoke the permit. And to involuntary transfer a permit, 30 Texas Administrative Code, Section 305.64I9 requires a demonstration that the transferee has the ability to comply with the permit, and we have no such demonstration on this record. So even if the facts might otherwise support an involuntary transfer, which I have my doubts about, we still could not do so on this petition. Turning to revocation, the ownership issue was not raised when the permit was issued, and whatever Cali Cate's representations were at the time, they do not render the permit void ab initio. I think that would take us into a totally different policy direction that I'm not prepared to take this commission. The revocation analysis turns on the conduct of the current permittee, Aguilas, and I don't see evidence of bad intent in Aguilas's statements concerning property ownership. On the other hand, revocation doesn't require intent. It requires good cause. And under 30 Texas Administrative Code, Section 305.66A4, that could be a mere failure to disclose relevant facts. However, subsection G1 also requires that the commission find that the violation is significant and that Aguilas has not made a substantial attempt to correct the violation. And on these facts, I'm not sure that I would describe the representation about property ownership as significant, and there's some debate about what the intent or what was communicated in the form by the words will be located. But setting that aside, even if there were a significant failure or violation, I view Aguilas's application to amend the permit as indeed a substantial attempt to correct. And accordingly, I don't see a basis for revocation. So I come down on denying the petition. Commissioner Lindley.
I'm in agreement. I'll just say that. I was kind of looking through my notes to make sure you kind of covered everything I would want to say. Quite frankly, I thought both the executive directors and OPIC's arguments were very good, and all the parties involved. This one's complicated and new, and I hope we don't see many more of these. But instead of going through kind of what I was going to say, because I think it would just be copying what you said, I'll just say I'm in agreement.
Well said, and I'll take the same course. I think it was instructive for me, that last factor about the attempt to correct the issue, which I will grant the points about the significance of potential accuracy or inaccuracy of the control of property on which the facilities we regulate will be issued. However, those words will be located that you highlighted, Chairman, were the point where I think the potential clarity snagged. I'm comfortable on denial.
I can attempt a motion then, I guess. I would move that we deny the petition filed by Catalonian LLC for the commission to involuntarily transfer, revoke, and reissue to petitioner TCEQ permit number WQ00158430001.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of gifts and donations of $500 or more in value given to the TCEQ, submitted for approval in accordance with Chapter 575 of the Texas Government Code. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Mendez of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Mendez. I have none. Colleagues, any questions?
No?
Ms. Smith, has anybody signed in to speak?
No one is signed in on this one.
Thank you. And what does the Office of Public Interest think about this item?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, Public Interest Counsel. OPIC supports approval and issuance of the resolution acknowledging the ED's acceptance of gifts and donations.
Thank you, Mr. Arthur. Colleagues, I've reviewed this item. I agree.
I agree.
Likewise, I move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCQ intra-office memorandum to the Commissioners dated December 22nd, 2023, docket number 2023-1685-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of TCEQ's historically underutilized business program FY 2023 report. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Clarabelle Diaz, HUB Program Coordinator of the Financial Administration Division. I have with me Yolanda Davis, Deputy Director of the Financial Administration Division, and Amy Mendez, Attorney of the General Law Division. We are representing the Executive Director. The TCEQ HUB Program Coordinator reports, communicates, and provides information directly to the agency's Executive Director and Commissioners on a quarterly basis. To assist TCEQ with the HUB compliance, the duties and responsibilities of our HUB coordinators include, but are not limited, facilitating compliance with the state agency's good faith effort criteria, HUB reporting, contract administration, and marketing and outreach efforts for HUB participation. The Texas Comptroller of Public Accounts, CPA, prepares a consolidated report on a semi-annual and annual basis, which is based on a compilation, and analysis of the reports submitted by each state agency, including TCEQ and other information available to the Comptroller. This item contains a summary of TCEQ fiscal year 2023 annual historically underutilized HUB subcontracting expenditures for goods and services between September 1st, 2022 through August 31st, 2023. TCEQ HUB goal attainment for fiscal year 2023. Procurement category, commodities. The total expenditures percentage is 21%, which is a statewide HUB goal. TCEQ's HUB goal was 36.39. The actual TCEQ HUB expenditures were a little bit over $2 million. Other services, the statewide HUB goal is 26%. TCEQ HUB utilization was 41.23%. The total amount expended was a little bit over $22 million. Professional services, the statewide HUB goal is 23.7%. TCEQ actual HUB utilization was 16.49, a little bit more than $1 million. Special trades, the statewide HUB goal is 32.9%. TCEQ actual HUB utilization was 25.84%, a little bit more than $71,000. The total amount for HUB expenditure was a little bit more than $25 million. TCEQ HUB utilization by HUB categories. Asian Pacific, the total expend was $4 million. The percentage of the HUB utilization was 15.78%, and we have a total count of 17 vendors. Black, the total HUB expenditures was $3.1 million. The HUB utilization was 12.18%. We have a total of 18 vendors. Hispanic, the total HUB expenditures was $3.4 million. The HUB percentage was 13.5%, and the total count of vendors is 28. Native American, we do not have any expenditures nor vendors. Service disabled veteran, $500,000 total expend, 2% hub utilization, and we have 5 vendors. Woman, total hub expenditures, 14.4 million. The percentage was 56.53%, and we have a total of 79 vendors. Fiscal year 2023. TCEQ ranked 4th among agencies spending more than $5 million in terms of the percentage of agency expenditures spent on hubs. Total TCEQ FY23 expenditures, a little bit more than $60 million. Of the total expenditures, hub expenditures equal a little bit more than $25 million, which is 38.18%. For TCEQ to have performed precisely at its goal level in each hub category, 21% for commodities, 26% for other services, 23.7% for professional services, and 32.9% for special trades, TCEQ would have generated a little bit more than $16 million in hub expenditures. TCEQ's FY23 hub expenditures total a little bit more than $25 million, 51% higher than what it would have been if the agency had obtained the precise goals in each of the categories. TCEQ surpassed its commodities and other services goals. TCEQ did not meet its professional services goal, 23.7. The agency does not usually attain this goal. A key challenge in this area is the limited presence of hubs providing the services needed. And note, professional services in fiscal year 2023 increased to 16.49 utilization. The decline in previous years was attributable to regular fluctuations in engineering work at remediation sites and a correction to expenditures coding. A few coding corrections reclassified some expenditures from professional services to other services. Previous fiscal year professional services utilizations, fiscal year 19, 8.27%, fiscal year 20, 9.58%, fiscal year 21, 12.23%, and fiscal year 22, 5.2%. TCEQ expends the least in special trades and did not meet the goal of 32.9. Fiscal year 23 expenditures total $275,000 of the amount. Hub expenditures were $71,000, which equals 25.84%. TCEQ attended 58 economic opportunity forums to market the hub program to vendors and participated in the statewide hub discussion workgroup. The hub program participated in the TCEQ Environmental Trade Fair, Governor's Office Small Business Summits, Greater Houston Business Procurement Forum, doing business with our state of Texas agencies and institutions, Women's Business Council Southwest, Connections to Contracts, the Small Minority Women and Veteran Business Owners Conference, Senator Miles Houston Minority Supplier Development Council Spot Bid Fair, Senator West Spot Bid Fair, and more. TCEQ sponsors 2 mentor-protege agreements between prime contractors and hubs to assist hub growth and development. Sponsoring mentor-protege program is required for agencies with biennial appropriations exceeding $10 million. The action plan for 2024. The hub program will continue to meet with directors and the direct reports to review expenditures patterns, encourage hub utilization, and field questions. The hub program will continue additional measures to improve hub utilization efforts, which will include recruiting through outreach activities as noticed above with organizations such as Chambers of Commerce, hosting workshops for hubs on how to do business with the state of Texas and providing training on the new hub subcontracting plan, HSB, inviting hubs to participate in pre-solicitation conferences to meet prime contractors, and encouraging program areas to continue addressing hub utilization in their procurement and contracting. This concludes my report.
Thank you, Ms. Diaz. I just wanted to confirm that I understood this correctly, that we are far exceeding our expenditures in the aggregate. But if you look at the categories, we're underperforming in professional services, but dramatically overperform in the other categories, right?
Yes, sir.
Yeah, and I know that professional services category is always a tough one. Colleagues, any questions or
No,
comments?
thank you very much.
Ms. Smith, do we have anybody signed in to speak?
No one on this one.
And does the Office of Public Interest Counsel have any thoughts?
Chairman, we have no comment except to say that we appreciate this report, and we especially appreciate the important work of the HUB program.
Thank you for that, Mr. Arthur. Yeah, this it's a very important program. It's important to the agency, so we really appreciate your work, Ms. Diaz and Ms. Davis, and to every TCEQ employee who's involved in the contracting process. We appreciate your help in doing what we can to amplify utilization. And there's no action necessary on this report, so we thank you for that. And Ms. Smith, I'll ask you to call the next item.
Thank you.
Item number 6 is consideration for adoption of new oil and gas extraction activities, TPDES general permit number TXG 310000. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and the Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. With me today is Chris Linendahl, also with the Water Quality Division, and Kathy Humphreys with the Environmental Law Division. Staff requests adoption of new Texas Pollutant Discharge Elimination System, TPDES, General Permit Number TXG 310000, which proposes to authorize the discharge of various waste streams and the prohibition of discharges of various waste streams from 3 distinct categories of oil and gas extraction operations: onshore stripper well facilities, coastal facilities, and territorial seas facilities located in the Gulf of Mexico out to 3 statutory miles from the Texas coastline. The purpose of this new TPDES general permit is the implementation of House Bill 2771 from the 86th Texas Legislature in 2019, which transfers permitting authority from discharges of certain waste streams from crude oil and natural gas facilities into surface water in the state from the Railroad Commission to the TCEQ. Furthermore, the draft general permit proposes to authorize these discharges under one single combined authorization under the TPDES program versus the previous requirement to obtain separate state and federal authorizations to discharge. All entities seeking to discharge under the authority of the general permit are required to submit a notice of intent to obtain authorization to discharge. In a letter dated September 14, 2022, the U.S. Environmental Protection Agency submitted recommendations with no interim objection on the draft general permit and fact sheet, authorizing TCEQ to issue the general permit. Water Quality Division staff made revisions to the draft general permit and fact sheet and notified EPA of the revisions. Public notice of the draft general permit was published in the Texas Register on May 5, 2023, and in the Houston Chronicle and Dallas Morning News on May 12, 2023. The public comment period ended on June 12, 2023. Public comments were received Revisions were made to the draft general permit, and a response to comments was developed and is included in the backup material before you today. Staff recommends adoption of this general permit and the response to comments. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We're available for any questions you may have.
Thank you, Ms. Gibson. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, has anybody signed in to speak?
No one has signed in on this one.
And what's the view of the Office of Public Interest Counsel?
Good morning again, Chairman, Commissioners, General Counsel, and Executive Director. My name's Eli Martinez with the Office of Public Interest Counsel for the record. We reviewed this rulemaking package, which creates a combined state and federal authorization to discharge waste streams associated with oil and gas activities by facilities within 3 miles of the Texas coastline. We've concluded the rulemaking serves a public interest by fulfilling the legislative mandate of HB 2771 and creating a permitting mechanism that applies the protections of EPA's existing NPDES general permit and then bolstering these protections with the requirements of our Chapter 307 Texas Surface Water Quality Standards. This effort included frequent and extensive efforts to solicit comments by the public, stakeholders, and the EPA, and we agree with the disposition arrived at by the team, including some technically complex decisions that had to be made, especially around wet testing requirements. And I do appreciate the patience of the executive director's staff in explaining some of those decisions to someone with very little scientific background. So, our analysis of this rulemaking is that it will streamline the combined state and federal authorization process while maintaining protection of the public and our environment. And for these reasons, we support adoption. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. I have none. Colleagues, any questions
No,
for
thank
OPIC?
you.
Okay. Well, as you know, this permit is to implement legislation and delegation, placing the described discharges under TCQ's jurisdiction. I also really appreciate the robust stakeholder process. I think that probably accounts for the fact that we had just one comment on this action. So again, thanks to our stakeholders. Colleagues, I think I'm ready to move forward with adoption.
As am I can make a motion. I would move that we adopt new TPDES permit number TXG310000 as recommended by the Executive Director and issue the Executive Director's proposed resolution.
And to clarify, I think you missed the word general permit, but
I do mean the TPDES general permit. Thank you.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, please call the next item.
item number 7 is the consideration for adoption of the new Texas Commission on Environmental Quality state-only oil and gas extraction activities general permit, number WQ G280000. The Executive Director's staff is here to present this item.
Good morning again.
Good morning again, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, again, I'm Shannon Gibson with the Water Quality Division, and today with me is Chris Linendahl and Kathy Humphreys with the Environmental Law Division. Staff request adoption of new TCEQ state-only general permit number WQG280000, which proposes to authorize the discharge of various waste streams and the prohibition of discharges of various waste streams from the outer continental shelf facilities located in the Gulf of Mexico between 3.0 and 10.357 statutory miles from the Texas coastline. The purpose of this new TCEQ state-only discharge general permit is the implementation of House Bill 2771 from the 86th Texas Legislature in 2019, which transfers permitting authority for discharges of certain waste streams from crude oil and natural gas facilities into surface water in the state from the Railroad Commission to the TCEQ. This general permit is not under the authority of the Texas Pollutant Discharge Elimination System program, and the U.S. Environmental Protection Agency did not provide National Pollutant Discharge Elimination System authority to states beyond 3.0 miles from state coastlines. Regulated entities will gain the benefit of obtaining a streamlined authorization under the general permit versus the previous requirement to obtain individual discharge authorizations from the Railroad Commission. All entities seeking to discharge under the authority of the general permit are required to submit a notice of intent to obtain authorization to discharge. Again, this general permit is not under the authority of the TPDES program. Approval for issuance of the general permit is not required to be obtained from the EPA. Public notice of the draft general permit was published in the Texas Register on May 5th, 2023, and in the Houston Chronicle and Dallas Morning News on May 12th, 2023. The public comment period ended on June 12th, 2023. Public comments were received, revisions were made to the draft general permit, and a response to comments was developed and is included, again, in your packet material before you today. Staff recommends adoption of this general permit and the response to comments. Additionally, staff requests the authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we're available for questions.
Thank you, Ms. Gibson. I have none. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Martinez.
Good morning again. Eli Martinez with the Public Interest Council for the record. We reviewed this rulemaking adoption package, which creates a state-only authorization to discharge waste streams associated with oil and gas activities by new and existing outer shell facilities located between 3 and 10.357 miles of the Texas coastline. We concluded the rulemaking serves the public interest by fulfilling the legislative mandate of HB 2771 to create a permitting mechanism that safely and adequately addresses those discharges previously regulated by the Railroad Commission that we have now been tasked to oversee by extending the protections of EPA's existing NIPD's general permit, and then once again bolstering those protections with the requirements of our surface water quality standards located in Chapter 307 of our rules. This effort also included frequent and extensive efforts to solicit comments by the public, by stakeholders, and the EPA, and we agree with, once again, with the disposition arrived at by the team, including some complex decisions that had to be made, once again, around wet testing requirements, but also produce wastewater flows and compliance schedules. And our analysis ultimately of this rulemaking is that it will streamline our state authorization process while maintaining protection of the public and the environment, and for those reasons, we support adoption.
Thank you, Mr. Martinez. Colleagues, to avoid being redundant, I'll simply agree with Mr. Martinez. I want to add, again, my thanks to all the stakeholders who participated in this process, and I am ready to move forward.
I move that we adopt new TCQ state-only oil and gas extraction activities general permit number WQG 280000 as recommended by the Executive Director, and issue the Executive Director's revised proposed resolution.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That brings us to our enforcement docket, and those items are 8 through 22. And the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are new business items 8 through 22. The total assessed administrative penalties are $523,658, with $91,040 deferred, $196,785 applied towards supplemental environmental projects, and $235,833 to general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Colleagues, any questions? Ms. Smith, I understand we have some folks who want to comment on the enforcement docket. I'll ask you to go ahead and call those commenters.
Yes, we have people signed in on item 11, and the first person that we have is online, I believe, and her name is Ms. Vanessa Hanais.
I am here.
Good morning, Ms. Hanais. The floor is yours. Go ahead.
Okay, so basically, I have a lot of points on this. So, there have been two enforcement actions, like two separate investigations on the WS Campus Holdings, and one of them was for constructing, starting construction without permits, and that was back in, the construction actually started back in 2021, December 3rd, I believe, through Brodus Construction, and they had taken out the NPDES permits under a different site name. So they've got multiple RN numbers, multiple CN numbers, and like a lot of things are wonky here. It's a lot like that first issue you guys were talking about regarding ownership and site activities and things like that. So yes, basically it had started without the Edwards Aquifer permits back in 2021, and then they were given in their notice of enforcement, stuff like that, told they had to cease activities, which they never did. They continued to build, outside, like they were only supposed to, in the original application, supposed to take up 6 acres or something like that. And then they continued to build out of that area continuously for an entire year. And so when they had the second enforcement action, it was for a separate piece of property. It was not even within the 50 acres that the enforcement action says here. And so they're outside of that, disturbing huge amounts of land. And then they rolled that because they were cited again for building without permits. And they got a new Edwards Aquifer Protection Program permit, but under a different name again, like they just and a different RN number. So they said it was a new development, which, in this enforcement action, it's now just rolled together as if that wasn't the case. So basically it's a 770 acre property they own, and they've segmented it and told everyone that they've got 40 acres here just to avoid regulations. And in fact, they've got the contributing zone permits. They're in, like, part of their property's in the recharge zone, and everything that happens on that property is going to go directly into the recharge zone. So I have submitted many things, some of them, trying to intervene in this, which was denied. I have, it's just like to say that $8,000 is enough for what they've done is insane. And it's wrong to do to the people, living adjacent to them.
That's time.
Due to their activities.
And Ms. Hanais, I'll ask you just to finish your thought.
Yeah, so it's just completely ridiculous to continue to, they've taken no action to remediate anything. In fact, they're still building beyond the bounds of any of their permits. That's all.
Thank you for your comments, Ms. Hanais. Ms. Smith, who's next?
We have Thomas Blahnik.
Mr. Blahnik, are you with us?
He is. I don't know if he's got.
I am.
Hand it over to him.
Oh, we hear you now, sir. Go ahead when you're ready.
Okay, Megan, the presentation that you have up was actually for me, so thank you for having that up. Can you put that back up? Perfect. And if you can go to slide 1. Essentially what I'm showing is they're working outside of their permits and continuing to do so. I have documented here that their construction actually began back in May of 2021. They did not even apply for a permit until September. While it was still pending, you can see in the month of December of 2021, they had already disturbed massive amounts of ground. Continue on to slide 2. this continues to show the large earth movers and the large amounts of land that they had been disturbing. You can go on to number 3. We're starting to see that in February of 2022, I don't believe their permits had been approved yet. They're already blocking ditches with the rock debris. They are destroying the ditches with heavy equipment. You can see there on the right. You can see in April, carrying on, how much they have, how much land they've disturbed. We can go on to number 4. So this here in March, you can see that little pond that was on the property. This is actually, they have their land segmented. I believe it's almost 700 acres that they have here. They were only permitted to build, as Ms. Hinnice before me said, on something like 10 acres. It was something small. This is 3 properties that they own to the right of that, which is to the west if you're looking at a map. Right now we are looking from north to south, and the previous pictures are over to the left. So this pond here, they built their first shooting range right on the pond. They built it right over the pond so that their shooting led into the pond that was already on the property when they purchased it. If we go on to the next slide, you can start to see their construction. They have slurry ponds, they have cesspools, they have large amounts of oil and things that they have already spilled into the property here. If we go on to, I believe I'm on slide 6 now, the shooting range. Once they got further along, in just a minute, you're going to see they started building their massive ranges that they have where we started on 7. Begin on slide 6. They've started with that little pond that they had. They have dug out to a massive pond. This is right before Salado Creek, which they have dammed. You can see that road that is just above that massive pond that they dug. They have dammed Salado Creek with that road that they drove across it. And then if you go on to 7, you can see where they're building their massive ranges. Where you can go on to slide 8, you can see that they're already holding massive events, and you can see how big the ranges are. Those ranges are in the 100-year flood zone. There are 11 documented endangered species right in this
Mr. Blahnik,
area.
sorry to interrupt. I'll just ask you to finish your thought, and so we can get on to the other commenters.
I will finish right now. Their ranges right there that you see, they are dumping approximately 1 million rounds a year based on their own video testimony into that recharge zone. And right behind their range, less than 150 yards, is Salado Creek. Thank you.
Thank you, sir.
And I would just like to remind the commissioners that we have 2 violations before you and notice today, and they only regard construction at the site without an approved Edwards Aquifer program plan. And our next commenter is Mr. Scott Addison.
Good morning, Mr. Addison.
Good morning. Am I coming through okay?
We hear you loud and clear. Go ahead, sir.
Great. I came aware of this some weeks ago. I'm an environmental planner. I'm kind of a crusty character. I go back to work decades ago in Washington State and going to them and talking to them about Section 303 watershed plans. And remember the Department of Natural Resources didn't know what I was talking about back in those days, but we've come a long way. What I've observed in these proceedings so far is that there's kind of the regulatory process has kind of understated the land holdings of this entity and the scale of their activities, and the activities involving known serious contaminants. The thing I want to bring to focus, and I did send this by email. I don't know if it has gotten before you, but I sent a PDF of a USGS map of the area, which shows the both north and south branches of Salado Creek, running through that area. And then I note that the reference map used by TCEQ does not show Salado Creek or these tributaries. The thing that's kind of concerning to me is that how can you presume to regulate something you don't recognize, where you don't even recognize the existence of those water courses running through the area contiguous to and on the properties involved. The regulations on watersheds going back the old days apply based on the proximity of activities to known water courses and how they affect floodplains and recharge areas. And candidly, basically this looks like a setup for caveats in terms of being able to say, well, there's we can declare non-significant impacts because we see no water courses close to the area or contiguous to these activities. And this basically is a setup to kind of overlook direct impacts on the floodplain and the recharge areas that are part of the Salado Creek watershed, that's part of the Edwards aquifer. And so basically, I suggest that you refer to what the USGS recognizes as the watershed and take a look at your maps, which seem to ignore that. Thank you very much.
Thank you, Mr. Addison. Your timing was impeccable. You landed exactly as time expired. Ms. Smith, who is next?
And again, I'll just remind the commission that this isn't an enforcement item about the adequacy of the plan or the approval of a plan. It is about the construction without a plan. The next person that we have on the list is Jay Humphreys, and I understand that they are on their way here but are not here yet.
All right. Well, tell you what, let's continue our conversation about this item without Mr. Humphreys, and if he gets here in time, we'll allow him to share his thoughts.
Yeah, and he is the final speaker signed in.
Okay. Nobody else signed in to speak. Mr. Arthur, let me turn to you for your general thoughts and any specific thoughts you may have on item 11.
OPIC supports adoption of these enforcement orders as presented by ED staff. Regarding item 11, I'll just note that I've corresponded with Ms. Hineyes multiple times and tried to serve as a resource in the way that OPIC can to help her navigate our processes and participate. I'll just leave it at that.
Thank you, Mr. Arthur. Appreciate that. And I want to give the Executive Director staff an opportunity to respond to anything you heard with respect to the comments on item 11. I don't have any specific questions. So before you begin, let me invite my colleagues to steer or direct or ask specific questions if they have any.
I don't have any right now, thank you.
If you have any thoughts about the comments, I just invite you all to share them. Okay, I'm seeing none. Any indication that Mr. Humphreys has been able to join us? I think not.
I don't.
All right. I appreciate the comments we heard this morning. As General Counsel reminded us, what's before us is a discrete enforcement action. We heard some testimony that may suggest different or ongoing violations that would be separate and apart from the item that's before us this morning. I didn't hear anything in the comments, nor did I see anything in my review of item 11 that would convince me that it did not follow our administrative penalty policy. So I'm comfortable moving forward with item 11, as well as the rest of the docket. Commissioner Lindley.
I would agree. I would just make the kind of obvious comment that I would hope that the company referenced in item 11 is paying attention. And, I don't know if they're here. I'm kind of surprised they didn't sign in to speak if they are. But your neighbors are watching, and I would think it would be of your best interest to be a good neighbor.
Very well said. I would add that management from our Office of Compliance and Enforcement is also in the room, and so they got the benefit of the presentation this morning.
Mm-hmm.
Commissioner Janeka.
I do understand that, Mr.
Okay. I think we may have Mr. Humphreys. Let's give him a chance. Are you there, sir?
Sir.
Okay.
My name is Jay. My name is Jay Humphreys. And my mother, Fama Humphreys, is the owner of the neighboring ranch. Well, it has one ranch in between us, and we are downstream of the staccato factory. The creek that runs through our property also runs right behind the firing firms that they have that they are currently firing into. And from what I'm told, this place is going to be the Disneyland of firing ranges. My cattle drink out of that creek. The reason why I'm not there right now is because I had to take the cattle to auction this morning and wasn't informed of this meeting until just last night. But I'm on my way to the meeting as we speak. I'm less than 10 minutes away. Anyway, I have my mother here with me, and we're both concerned about if it's going to be the Disneyland, quote unquote, Disneyland of firing ranges, where is all that leg going to go that has a stream, has the creek, the South Salado Creek, right behind the firing berms that they're firing at? Factory, they're building guns. I know they have to have sewage, I know Disneyland has sewage. I know that they probably have a sewer system of some kind. There's no sewer system on our road, on County Road 233. There's no sewer system out there. Where's the sewage going to go for their factory and for their apparently millions of people that are going to be showing up to fire guns out there at this firing range? It's very concerning, especially since I have cattle that drink out of South Salado Creek that is currently running right now. Anyway, that's my concerns, and I know that if I personally were to do something like build a factory like this out there, I know the EPA would be on me quick. So I don't know where they're at right now, but I feel as though there needs to be some attention to this. There was no sewage line built that I know of going to any sewer plant. I don't know where they're going to put their stuff, and stuff happens to roll downhill, and I'm downhill, and I don't want that. Anyway, I don't know what else to say.
All right. Well, thank you for that, Mr. Humphreys. And so that your trip isn't wasted and your mother's trip isn't wasted, when you get here, I would ask you to be in touch with folks from our Office of Public Interest Counsel, as well as our Office of Compliance and Enforcement, and they will be around and make themselves available to you. What I'm hearing is concerns that are outside the scope of what's in front of us this morning. But I will I'll allow you to share those concerns again with OPIC and our Office of Compliance and Enforcement to see how they might be able to help you with those concerns. Okay, I think I was about ready to, and thank you again, sir, for your comments. And Commissioner Janeka.
I'll chime in tersely, acknowledging that there were a lot of comments about, it sounded like issues that were aside the ones that we're responding to today, which is the request, the permission to construct the Edwards Aquifer Plan component that our agency oversees. To the extent that there's activities that sound like they're ongoing, I really do appreciate the input today from all of the residents and neighbors of this facility, and I would encourage you to remain in contact with the Office of Public Interest Counsel, with our Office of Compliance and Enforcement. Our inspection staff and enforcement staff will respond very seriously to these allegations in the appropriate manner. Today is not the appropriate place for us to respond to and attend to them. So I sincerely appreciate the apparent interest, and I will just encourage all of you to please communicate these ongoing concerns to our enforcement staff. Our agency really crucially does rely on engagement from the public to help police and ensure accountability in our regulated entities in the state. So I am grateful for your participation in that to that extent today.
Thank you, Commissioner. I believe we're ready for a motion.
I would move that we adopt items 8 through 22 as recommended today by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 23 is the consideration of the publication of and hearing on a proposed amendment to 30 Texas Administrative Code, Section 116.150E, and the corresponding revisions to the state implementation plan. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Suzanne Alexander with the Air Permits Division. With me is Terry Salem and Abigail Adkins of the Environmental Law Division, and Allison Stokes with the Air Permits Division. The proposed rulemaking would amend the language in 30 Texas Admin Code 116.150E to clarify the nitrogen oxide exemption for the El Paso non-attainment area applies only for the 1979 one-hour ozone standard, in accordance with the U.S. Environmental Protection Agency's approval of the NOx waiver. If adopted, the revisions to Chapter 116 will be submitted to EPA as a revision to the state implementation plan. Staff respectfully recommends approval for the publication of and hearing on the proposed revisions to Chapter 116 and the SIP. Staff also respectfully requests permission to make non-substantive revisions, if necessary, to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Alexander. I have none. Any questions, colleagues?
No.
Ms. Smith, is anybody signed in to speak?
And not on this item.
Mr. Arthur, what do we think?
OPIC has no objection to publication of this proposal.
Nor do I, colleagues. This appears to me to be a very simple clarification in our SIP, and I'm ready to put it out for public comment.
I agree.
I move we approve the publication of and hearing on an amendment to 30 Texas Administrative Code Section 116.150E and corresponding revisions to the state implementation plan as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 24 is the consideration of the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 311. The Executive Director's staff is here to present the item.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michaela Coleman with the Water Quality Division. With me today is Rebecca Villalba with the Water Quality Division and Michael Parr with the Environmental Law Division. The proposed rulemaking amends Title 30 Texas Administrative Code, Chapter 311, Subchapter H, Sections 311.71 through 311.75, 311.77, and 311.79 through 311.82 to expand permitting and financial assurance requirements for quarries in the new Coke-Stevenson Scenic Riverway, to continue requirements in the John Graves Scenic Riverway, and to extend the pilot program until September 1 of 2027. In addition, the title of Subchapter H would be amended to, quote, regulations of quarries in certain water quality protection areas, end quote. A public hearing on this proposal is scheduled for February 26, 2024 in Austin, Texas. Staff respectfully recommends approval of the publication of and hearing on Chapter 311, Subchapter H, Sections 311.71 through 311.75, 311.77, and 311.79 through 311.82. In addition, staff requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, Ms. Coleman. I have none. Colleagues, any questions?
No.
Ms. Smith, has anybody signed in to speak?
Yes, we have Mr. Josh Leftwich signed in to speak.
Good morning, Mr. Leftwich.
Good morning. How are y'all?
Good to see you.
Good morning, Commissioners and staff. I just would like to say that the Texas Aggregate and Concrete Association supports this rulemaking effort, and we really would like to be a stakeholder throughout this process, as we have with other rulemakings around this type of effort. One thing I'd also like to put forward is we really encourage TCEQ to complete an evaluation of the John Graves Waterways Act, as it was extended for another 2 years once this is sunsetted. So we'd really like to see a final evaluation of the overall program completed as directed in the original rulemaking and enactment of this bill. So we'd like to see that done upon completion and extending of this program. So thank y'all and look forward to working with y'all.
Thank you for your comments.
All right,
Appreciate that. Ms. Smith, has anybody else signed in to speak?
No.
All right. Mr. Arthur, what says OPIC?
OPIC has no objection to publication of this proposal.
Nor do I. This seems to be a pretty straightforward piece of legislative implementation that it enhances protection of our scenic riverways, and I'm ready to put it out for public comment.
I agree. I would move that we approve the publication of and hearing on the proposed amendments to 30 TAC Chapter 311 as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to items 25 through 29, the quadrennial rule reviews for chapters 216, 220, 303, 333, and 344 of the Texas Administrative Code, Title 30. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 25 through 29, the adopted rule reviews of 30 Texas Administrative Code, Chapter 216, Water Quality Performance Standards for Urban Development, Chapter 220, Regional Assessments of Water Quality, Chapter 303, Operation of the Rio Grande, Chapter 333, Brownfields Initiatives, and Chapter 344, Landscape Irrigation. As required by Texas Government Code Sections 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for the reviews of Chapters 220 and 333 were published in the July 14th, 2023 issue of the Texas Register and the proposed notices for the reviews of Chapter 216, 303, and 344 were published in the July 28th, 2023 issue of the Texas Register with 30-day comment periods. No comments were received for these rule reviews. Based on the review of these chapters, the executive director has determined that the reasons for the rules in chapters 216, 220, 303, 333, and 344 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of chapters 216, 220, 303, 333, and 344. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are here to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
Not on these items.
Mr. Arthur?
OPIC agrees that the reasons for initially adopting the Chapter 216, 220, 303, 333, and 344 rules continue to exist, and we support readoption of the rules in each of these chapters.
Thank you. Colleagues, I agree with that. There's still a need for each of these rule chapters. There were no comments. I'm ready to readopt.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code Chapters 216, 220, 303, 333, and 344 without amendment as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
The next item is our public comment session. The commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases which are subject to the ex parte prohibition found in the Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and the recitation of existing policy. And we have one person signed in, Ms. Lydia Ponce.
Ms. Ponce, are you with us?
Yes, I am. Good morning, relatives. It's a very healthy 2024 for everyone. I am calling from the unceded territory of the Tongva people, known as Sagna, infamously known as Venice, California. However, my work, I have one boot in Texas and one boot in California, and it's a wide stride. It's an honor to be with you, and I wanted to share a little bit in regards to the development and funding and support for Texas community, the improvements y'all are making. I love to see people working and, you know, everybody busy from Corpus Christi to Austin, Texas, and back around San Antonio. Those are the places we go, especially when we're holding ceremony. However, my concern as a grandmother, as a mother, as a woman, indigenous, I never hear of conversations of a cumulative impact. I know we have these things in California, and I also know that we are blue and y'all are red, but together we make purple. So I'm looking forward to working together with TCEQ in this 2024, because the tourist destinations, you know, depending on where you travel in Texas, really denote a favorable investment, looking favorable, but it's perfunctory. And I'm speaking specifically of the parks that are just constructed and funded right outside oil industry and refineries and the cracker plants. So this seemingly big, you know, petrochemical build out really doesn't bear fruits for all the children of the world, as we are definitely connected from waterways and from land to land. And we as indigenous people look at 7 generations forward. So here we've identified neglect and abuse of natural resources, which jeopardize the 7-generation healthy futures. So TCEQ and the Texas oil industry, with these, you know, ideas of what the community needs, it's just not forward thinking when it comes to the future of healthy children. We're looking at the empty swings and the empty climbing apparatuses at these parks. I've seen them in Corpus Christi. I think Austin was really beautifully utilizing, and San Antonio beautifully utilizing their parks and their waves. But I'm talking about the Gulf, where I like to go to eat mariscos, the seafood, and really enjoy the space. And, to add insult to injury, we've got TCEQ and the Army Corps of Engineers, are complicit with all these decisions, especially with today's agenda, without talking about a cumulative impact, and then void of local tribal people for consultation and consent. After all, Texas continues to be, taking a touristic approach when it comes to a performative daily cultural visit. It's
That's time.
can't be visited every day. TCEQ needs to really step up the state motto, which is friendship. So please call us in to work with you. We're Indigenous people and we're everywhere. Thank you.
Thank you for your comments, Ms. Ponce. Ms. Smith, is anybody else signed in to speak?
No one else has signed in.
All right, I'll ask you to please call the next items.
The next items are for closed session, and the commission will meet in closed session in room 4222, building F, at, should we say 11:15 approximately. And that will be as permitted by the Open Meetings Act, including Texas Government Code, sections 551071 and 551074, to take up and consider matters pursuant to items numbered 31 through 34 as posted and noticed.
The time is 11:02 a.m. We are in recess.
The cedar is The commission. The commission met in room 422 or 4222 of Building F for closed session from 11:19 to 11:40, recessed and then rejoined from 11:52 to noon on item numbers 32 and 34 as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. The agenda stands adjourned and the time is 12:13.